The third case on this morning's docket is case number 102119, State of Kansas v. Travis A. Montgomery.
May it please the court, counsel, I'm Corey Call representing Travis Montgomery. I would request 5 minutes for rebuttal, please.
5 minutes is granted.
Thank you very much. Mr. Montgomery, this is a case very similar to the case that was just discussed. Mr. Montgomery also had his probation revoked, and he was ordered to serve an 11-month sentence. He has completed that sentence.
And it's a little more straightforward on just simply whether it was abuse of discretion. You don't have any question about the revocation or the what occurred after revocation being legal or the aggregation of. We're straightforward with your clients admitted violating probation by failing to report, by using drugs, failing to participate in treatment, and failing to obtain employment. And his only argument is, yeah, but I should have had a third chance.
Yeah, I think that's it. If I could talk a little bit about the mootness, there's just a little bit of a hitch there that's different in that, and as you said, he stipulated to the violations as opposed to the judge making a finding that there were violations. And I don't think that makes a difference in the analysis, because the point we're making, that the harm to him is that he was found to be non-amenable to probation. And the judge is finding that he needed to go to prison as opposed to reinstating him on probation is part of the harm. And so I don't think the fact that he stipulated to the violation as opposed to the judge made the finding of violation, the key determination is that he is non-amenable to probation, and therefore we're going to send him to prison. That's the key part of it. But I do think the court accurately stated that he should have been given a chance to have drug treatment, or the intermediate. The judge's problem was that he didn't report. I think was the big one, and that how can we help a fellow that's not going to report? And of course, there was the intermediate option of sending him to a residential drug treatment program. That was an intermediate step the judge should have taken. But we would ask the court to find the district court did abuse its discretion.
Do we have any questions of counsel? Thank you, counsel.
Thanks.
Good morning. May it please the court, the state appears by Assistant District Attorney Jody Litvin. And the state contends that this issue is moot. We agree with the Court of Appeals' determination that because the defendant had served his underlying sentence, that the actual controversy has ended. And our position is that the argument that it may have some effect on him in a future criminal proceeding is too speculative, and it's just not concrete enough of a consequence for it to refute the finding of mootness.
Distinguish the future aspect and speculative nature and self-determination, don't commit the crime in the future aspects of the probation revocation, and tying that to the Spencer case. Distinguish that from criminal history, which we have said precludes mootness.
Well, I think, Your Honor, that the criminal history is much more of a concrete. There's statutes, and they are given a letter, and it follows them with sentencing. Whereas the probation revocation, it's still
the persuasive nature is not what Spencer said. How persuasive this is going to be on a future court. Well, you're basically saying that criminal history means there won't be any choice for the future judge, but on probation revocation, the judge may or may not factor that into his or her decision, but that's not what Spencer said. Spencer says, well, it's too speculative that we will even have that issue come up in the future, and for goodness sakes, all a person has to do is not violate the law, and then that issue won't even come up. So you can keep yourself from being prejudiced by following the law, and all of those, and it's speculative as to whether it's ever going to come up. Why aren't all of those factors, all of that rationale applies to criminal history score? If you don't commit another crime, your criminal history matters not a whit. And it's all in the future. It's only going to, if you increase your criminal history score, it's only going to matter in the future if you commit another crime.
I'm not sure if I'm following. Well, because I guess I would say that there are statutes that have determined that it's going to follow you, and that this court has held that is something that is important to take into consideration in the future. I'm not sure if I entirely understood what you were asking. I apologize. I think that I understand that it does all. The basis of the argument is that they have to recommit another crime, but I don't believe that a conviction of another crime carries more weight in your criminal history being convictions of other crimes rather than just having your probation revoked. I think it carries less weight than criminal history in that aspect.
Yeah, your position would be that I suppose that you have to consider criminal history in terms of another conviction, but you have a little more discretion in terms of how you would view a prior probation revocation. You can consider it, you don't have to. I suppose that would be a distinction.
Yeah, it's just a factor in one of many that they could use to impose an upward departure or place them on probation again.
But you don't have to. You can downwardly depart in the future.
That's true.
You have to consider. I guess you don't have to consider a probation revocation, but if the issue's brought up, the court would have to consider it, wouldn't he?
Yes.
So the speculation is whether a defendant or whether a prosecutor would bring up the issue in the future. That's the only speculation, is whether the issue will get raised in the future.
And it's still within the discretion of the court, even if it's raised. And there are other arguments that the defendant could make, other factors that could be in his favor as well. I didn't really have anything else to add. We would just respectfully request that you affirm the Court of Appeals decision that it's moot.
Did you hear my question about reliance on Spencer? It's not altogether clear that we're making a distinction between what is authority and what is just persuasive cases. This obviously is not binding on Kansas court. Would you agree?
I would agree with that. I think that they looked at the analysis that they did about the collateral consequences, though. I don't think they looked at it from the case in controversy point of view. I think they tailored it to that.
And I agree with that. We've got some in McAllister and here the Court of Appeals cited to NRA MR. We've used some pretty hefty language in this state about the rare circumstance under which an issue will be moot. We've talked about being clear and convincingly established. We've talked about ineffectual for any purpose. And we've, in McAllister, talked about any rights. How do we exclude future consequences as speculative and hypothetical within the context of being any purpose or any right?
Well, I think maybe you have to continue on reading in any purpose or any right involved in this action. And in this action, the only issue that's being brought up is whether the district court abused its discretion in revoking the probation. So any rights involved in this action are whether they abused their discretion for this one issue. So I would say that you can get around that because it's not any purpose in the future regarding anything.
So how does criminal history fit into that then? because criminal history wouldn't have any impact on this action because you've got your history when you come in. So how does that fit in?
I would say that's something that's statutorily created.
No. We've said that the fact that this conviction will increase your criminal history score for future crimes means that it's not moot. And I understood you to argue that when it says any purpose or any right, it was only talking about this case. Well, that doesn't translate over into our holdings that said increasing criminal history score for future cases is sufficient to avoid mootness.
Well, I think I understand what you're saying. I think that just the weight of the conviction has to be carried on through, and I think you can make a distinction by saying that the weight of a probation revocation, it's discretionary. I mean, it's less of a weight, and we don't have to carry it through the same way that we have to carry through criminal history.
I understand your argument, but what I'm saying is that sort of modifies our description, our prior description of a moot issue when we talked about being ineffectual for any purpose or affecting any rights. You would agree that this has the potential to affect rights and to have a purpose. You're just arguing it's too speculative and it's in the future, but we haven't said that. We haven't said immediate consequences, immediate rights when we described mootness, have we?
I don't believe so.
And why I was getting to all of that was, did the federal jurisprudence use such narrow language with regard to its concept of mootness? In other words, Spencer was applying federal law, and I'm just wondering if they had such a restrictive definition of mootness when they were applying that to future or speculative, or do you know?
I don't think they did, because again, we're just dealing with they were dealing with a parole revocation or a probation revocation. It wasn't dealing with, convictions in the future, which wouldn't become moot if you would challenge your criminal history score later. So I don't think so.
Do we have any further questions of counsel? Thank you, counsel.
Thank you, Your Honors.
You had reserved 5 minutes. Do we have any questions of counsel? Very well. Thank you for your arguments this morning. The court will take this matter under advisement. This time the court is in recess for 15 minutes.